Hello, everybody.
All right, the court will call the case of LVNV Funding LLC versus Lucretia Carr. Case
Good. Oh, sorry.
5C87.
Hello.
Good afternoon, Your Honor. Alexander Popov appearing on behalf of plaintiff.
Thank you. Ms. Carr, please state your name for the record.
Lucretia Michonne Carr.
All right, thank you. All right, we're on here on a motion to set aside the default judgment in this particular case. Ms. Carr, you filed this motion. There are two things that you have to be able to prove to the court. One is that there was good cause for the fact that you didn't show up to court, and two, that you have a meritorious defense, a valid defense to the claim. So both of those things have to be proven.
Yes. My first initial reason, I didn't know exactly how a summons works. And I had a few things going on at that time. I had an eviction I was in court for at the time, and I just didn't know what a summons was. I had never had one before. I thought that I was waiting on a court date to come to me. I didn't know that I had to go to the court and file an answer to the situation, and till I called and I spoke with someone, and then I figured out what my next steps were to discuss the situation. And then naturally, when I look at the information of the summons, the even paperwork that I received, I did not see. I'm sorry, I got some notes I wrote down. I was looking for a purchase agreement, legal authority. I didn't see my name, my account number, any of the things that are the bill of sales. And then I had wanted to do more research because I had a few different people contacted me about this same account. I even have an email from a different company that claims that they have this same account. So I don't even know what's actually happening at this time with this account.
Thank you, Counselor.
Thank you, Judge. Going by her motion, she stated that she had good cause because she didn't understand what the summons meant. The summons clearly directs the defendant to respond within 21 days. Therefore, we would argue that she doesn't have any good cause. If we go to the meritorious defense argument, in her motion, she said there was no meeting of the minds because multiple creditors contacted her. She hasn't provided any evidence of that, and if so, it's immaterial because there was mutual assent between the two parties, and the statements reflect that with payments and purchases. Therefore, we would argue that there's no meritorious defense either, but she hasn't provided good cause or a meritorious defense.
What does assent mean, so that she can understand that big word you just used? She's not an attorney.
Sorry, that we both came to an agreement.
And you're saying that was evidence because she spent using the account?
Yeah, so we gave her credit to use the account, and she utilized the account by making payments and purchases.
Oh,
And case law says?
The case law I can give you right now.
But the case law says if you do that, then that is considered mutual assent, correct?
Correct.
um, Cause I had the account with you,
You have an account with his client, ma'am.
and his client is,
LVNV funding.
and see, I don't have an account with LVN funding. You're saying that I had an account with, I don't, LVN funding, I never opened an account with them. I never signed any paperwork with LVN funding.
Yeah. So my client purchased the debt from the original creditor, which was Credit One Bank.
That's not what they said. They did not purchase it from the original creditor. I have some paperwork here that says they purchased it from somebody else.
So there is a chain of title. But we own LVNV. My client owns the debt.
But you said that I had an account with LVN, and no, I didn't. And they didn't buy it directly from that company.
It doesn't
We
matter whether they bought it from that company or not. They attached the bill of sale to this, and an assignment of the account is attached to the actual summons that you were served with.
And there's no purchase agreement.
Ma'am, you don't get to fight that once there's an assignment. That's not for you to fight. That's between him and whoever. If they have an issue as to whether or not it's a proper purchase, you don't get to make that. That's not your argument. Make.
It's not my argument to make that if there's a purchase agreement with my signature and stuff on there. I mean, not the purchase agreement. I'm sorry. I'm looking for,
Well, first of all, before we even get to that issue, I was just trying to address it because you brought it up. The first issue, ma'am, is that you can't come to court and say that I didn't know I was supposed to answer a summons. The summons tells you right at the bottom that you have 21 days after receiving the summons and a copy of the complaint to file a written answer with the court and serve a copy of the other on the other party or take lawful action within 28 days if you were served by mail or you were served out of the state of Michigan. It tells you right at the bottom what you're supposed to do.
unfortunately, I didn't understand what the paperwork was, so I didn't even process what that was saying to me. I didn't even know that's what it was saying.
Well,
I had never had a summons to court before.
the more unfortunate
And
piece.
then I Googled summons and it said
Miss
that I would be sent something in the mail
Carr,
according to a
Miss
court
Carr.
date.
Miss Carr, I know you hear me talking to you.
I apologize.
I
I'm
don't
not
like
trying to irritate you. I was just telling you what from
speaking
my
over me
understanding.
again.
I'm not trying to.
Stop speaking over me.
When I'm speaking, you wasn't speaking. I'm sorry. I wasn't trying to speak over you. I'm just trying to understand what was going on.
I
And I
was
just didn't
talking and
understand
then you
it.
started talking. That's what's going on. I was explaining. I was actually reading when you started talking, ma'am. So please don't do that. Okay?
Okay.
So as I was reading to you, this is what is required by this piece of paper. Whether you have an understanding of that or not, doesn't change the fact that you were served with the document that says that. The law says that you are required to read it and to understand it or to get legal assistance. You don't get to come to court and say, I didn't understand it. That's not the way this works. Now, what is it that you want to say?
I don't know. I mean, I know what it says, but I just didn't understand it. So, I mean, if I didn't understand it, then I called to get some advice to understand what was being said and what's handed and what was given. I just didn't understand what the paperwork said. I mean, I don't know. I know what the law says. I know what the paper says. But when I read it, it didn't process to me what I had to do next. So I called and I spoke to a clerk and they directed me to that area. And I said, oh, this is what it says. And then I didn't know. I just didn't understand it. I know the law wants me to. I know I may be irritating you, but I just didn't understand what I was reading. And I had wanted to apologize and see if I can have the opportunity to look over the evidence and see what I was being, sued for and who was suing me. That's all. I just didn't know. I apologize.
I,
I have the opportunity.
I'm not. All right. Are you done yet, ma'am?
Yes, I am.
All right, I'm not asking you to apologize for not understanding. That's not what I'm upset about. I'm upset because when I was talking, you kept cutting me off. That is irritating.
Yes, ma'am.
As to the second part, because there are two prongs. Even if I were to give you the benefit of the doubt, then you have to get to the second prong of this, is whether you have a meritorious defense. And the things you're talking about are not a meritorious defense to this. There is a proper bill of sale that they have that allows them to actually sue you. So the second question is, what are you trying to tell me about your defense? Because there's no purchase agreement. That's not what this type of case is. So what are you trying to tell me about that?
I was thinking, I didn't mean purchase agreement. I was looking for more information for the company to have because I'm not a lawyer, I do not know all of the information. I had a short time to research a few things. I would need more time to research a few more things of what's all needed to be provided to say that they own the debt and that I am responsible for the debt.
Mhm.
That's all. I just needed more time to look over it. My opinion, I didn't see any of my account numbers in any of the information that was given over. I didn't see any dates on any of the paperwork when the signatures was put on there. I didn't see any of that.
All right, so when a action is filed in court, ma'am, first things first, no one puts full account numbers on it. They're supposed to be blocked out. That's considered personal identifying information. So you would not receive it with that on there. Secondly, the bill of sale is attached showing that they now own the debt and they are able to sue you for this particular action. Before I make a ruling on your motion, do you want a chance? And this is over a credit card debt with Credit One Bank. So it's a very cool thing. You can talk to them and see if you want to resolve this before I make my ruling. Maybe they'll work out something with you, or you can choose to not talk to them and I can make my ruling. Do you want to try to talk to them and see if there's something you can work out?
Sure, I don't mind talking to them.
Okay. We'll see if there's something the two of you can work out. I'll put you in a breakout room first and then I'll call the case, okay?
Okay.
Thank you. All right, the court will recall the case of LVNV Funding LLC versus Lucretia Carr, case number 25C 1087. Mr. Popov, please state your appearance again.
Yep. Good afternoon, Your Honor. Alexander Popov appearing on behalf of plaintiff.
All right. Miss Carr, can you please state your name again?
Lucretia Carr.
All right. Where are we with this matter, Mr. Popov?
Judge, we were unable to reach a resolution.
All right. So, having said that, then I will have to make a ruling on the order regarding the motion to set aside the default. As the court has indicated earlier, there are two standards that must be met. One is that there's a good cause, meaning a good reason to find that the defendant did not show the court or did not answer the complaint. As I indicated earlier, the fact that the defendant didn't understand the document is not actually a good reason to not set this aside. In addition to that, I haven't heard anything that would satisfy a meritorious defense. The motion to set aside is denied. I will sign an order to that effect. We're all set here on that particular case. Have a good day.
You too, Judge. Thank you.
Be safe, be well, sleep sweet, and much love.